I'm Jennifer Romig, a professor here at Emory Law School, and my guest today is Todd Stanton. Todd is the principal of Stanton Law Firm, a 10-attorney employment firm here in Atlanta, Georgia. And I've invited Todd to talk about an important issue in the news and in the course, which is the employee-independent contractor distinction. Todd, how does it typically come to you? You're an employment attorney. How do you typically encounter the question of employee versus independent contractor?
Well, I will say, first of all, thanks for having me. Second of all, this is probably the top question we get that makes our phone ring. And it's usually a business calling me saying, I have a contractor who is now suing me for some employment law problem. Or I have some contractor who is now trying to get unemployment. Some contractor who is trying to take advantage now of the employment law framework that we normally operate under. Usually it is coming to me with a dispute or something has fallen apart in a contractor relationship. And almost invariably we determine that the contractor relationship was an inappropriate relationship and it should have been classified as an employment relationship.
So let's say I'm an employer and I need people, I need someone to do the business, to help my business do its work. And I bring in a worker and we sign a contract that says she is an independent contractor. Doesn't that make her an independent contractor?
That's what's making my phone ring. Yes, most businesses will think that's the case. Unfortunately, whether somebody is a contractor or an employee is not a matter of agreement. Right? We can have that contract in place, and having that written contract in place is a necessary but not sufficient mechanism by which to make that designation appropriate. The government is going to want every worker to be classified, or as many workers as possible to be classified as an employee. It provides the protection of the Equal Employment Opportunity Commission in Title VII, the protection of the Department of Labor and the Fair Labor Standards Act, the protection of unemployment insurance, the protection of workers' comp, the protection of the Occupational and Safety and Health Act. Businesses, on the other hand, want the flexibility that they think that contractors provide. And in my experience, businesses who want to favor contractors, who want to hire or engage contractors rather than employees, often do so misunderstanding the flexibility that the employment classification already provides.
So, well, if employment, you named off all those different laws that apply to an employment relationship, how is it really flexible?
Well, I would say that they're going to be classified as employees anyway. We might as well go into it with eyes wide open and classify them correctly from the beginning. Again, back to the organization who calls me with a contractor dispute. In 9 out of 10 cases, we're determining that these folks really should have been classified as employees from the beginning, right? And in many instances, the business that's coming into it has made false choices, right? They've said, I want this person to be a contractor because I can fire them at any time. Well, we can fire an employee at any time. That's the employment at will doctrine. They're coming in saying, I want them to be a contractor because I don't want to pay them overtime. Well, no kidding, nobody wants to pay anybody overtime. But that's one of the reasons that they're going to be pushed back into that employment category.
So you can't escape the doctrine because the reason for the doctrine is something you're trying to avoid.
Exactly. And so by going into it with eyes wide open and making sure that we've set them up properly as employees, we can adjust for that. We can get it to your payroll. We can make sure that your payroll expense doesn't blow your labor budget, right? Excuse me. But if you are whistling past the graveyard thinking these folks are classified correctly as contractors, when it comes unraveled and we start pulling that string, you're going to have tax consequences because you haven't withheld properly. You're going to have workers' comp issues because you're not insured properly. You're going to have overtime issues because you haven't been tracking their time or paying them time and a half, their regular rate for hours worked in excess of 40. So once we start pulling on that misclassification thread, the consequences can be pretty severe. If a business wants to set folks up as contractors and it's an appropriate designation, there's several steps we can take to do that, but it's better to get it out in front and do it correctly from the get-go rather than trying to retrofit that employment relationship into the contractor designation.
So what would be an actually appropriate scenario that would fit the definition of non-employee or independent contractor?
Again, a narrow circumstance. There's a couple, every agency has its own test for what's a contractor versus an employee. The IRS test is a little bit different from the EEOC's test. It's a little bit different from what the Department of Labor uses. It boils down to a couple things. Does the organization have control over that worker? If they're setting hours, if they're using uniforms, if they're providing tools, if they're dictating the exact measure of their work, that starts to look more like an employee than a contractor. At the same time, what's the nature of the work that's being done? If I hire a painter to come in to paint my offices, I have very little doubt that the individuals who I engage to paint my offices are going to be classified as employees of Stanton Law. Not only because
they will be or they won't be, the painters.
They will be contractors. They will be appropriately designated as contractors. I'm not providing their tools. I'm not setting their hours of work. I'm giving them a project and they're doing it. And I think most importantly, Stanton Law is not a painting enterprise.
Right.
They're coming in to do something outside of what it is that I normally do. If a business, say a marketing firm, is hiring, or excuse me, engaging contractors to come in and do marketing functions, that starts to make that individual look more like an employee of the marketing firm than if they had somebody to come in to do IT services. Right? The IT services, you can classify an IT provider as an employee of a marketing firm, but it's also okay to hire an outside firm to come in to do the IT, to outsource that for the marketing firm. That's a contractor relationship. The marketing piece is going to be more of the employee classification.
So you've touched on this, but I think I want to conclude by asking you, how do you see your role as a lawyer in working with clients to respond to this type of situation and to prevent or anticipate and get ahead of it?
So if a business comes to me in a planning capacity, right, to say, should we be classifying this particular position that we're going to be hiring as a contractor or an employee, I'm going to walk them through why I think they should be and why the safer, more conservative route is to make them an employee. Or if we know that they're a contractor, that they go off to be a contractor. Making sure that we set up the agreement in place. If the determination is made that I want this person to be a contractor, business has good valid reasons that I say, okay, that's good enough to do. We can set a contract in place that protects as much as possible that contractor designation. First of all, we're going to call it a vendor relationship, not a contractor relationship. You and I were talking earlier. When I hear the term independent contractor, when the DOL hears the term independent contractor, red flags go off that this is a misclassified employee. It's just
people are using
cliche.
Right?
Yes. So we started calling it a vendor relationship, right? Setting the definition, setting the expectation just a little bit different. That vendor contract that we're going to pay the project fee on a 1099 at the end of the year. I set it up so that we only pay those to federal employment ID numbers, not to social security numbers. Another red flag is where an independent contractor is getting those project fees paid on their social security number. That's going to be a big problem. So we set those little sorts of smaller tweaks to give the business the arguments that this person was properly classified as a contractor, not the default of being an employee.
This has been really informative, and I thank you for your time, Todd.
Thank you, Jennifer.